Here in Washington, D.C., since we're not a state, crimes get prosecuted by the U.S. Attorney's Office for the Federal District for the District of Columbia. Terrible name, I know, but even worse than that, right now, the interim head of that office is possibly the biggest POS in the country. Yes, Donald Trump rewarded his #1 sycophant, Ed Martin, with a prestigious job leading the most powerful prosecutor's office in the country, a job for which he has zero experience and is perhaps even less qualified if having the basic standard of ethics is an important qualification. And due to our little quirk of federalism, the U.S. Attorney's Office for D.C. is the only district with the authority to prosecute both federal and local crimes, granting it incredible power. And due to its proximity to the seat of government, the U.S. Attorney's Office in D.C. often deals with the highest profile cases and those involving the people actually governing our country. And historically, this was the office responsible for prosecuting Watergate and the January 6th insurrection. So conservative or liberal, this is where the country needs its best lawyers. But now President Trump has nominated Ed Martin, someone who is both a terrible lawyer and a terrible person, to be the permanent head of that office. Chaos lawyer Liz Dye is going to break it down for you because I just can't even.
Thanks, Devin. In his short time leading the U.S. Attorney's Office in D.C., Ed Martin has made quite a name for himself. It's not every lawyer who could mess up the First Amendment, basic criminal procedure, and the role of the Department of Justice all in one tweet. Whether he's slobbering over Elon Musk, threatening random Democrats, or attacking his own staff, the new U.S. Attorney for D.C. is making a big impression. But okay, let's start at the beginning. Who the is Ed Martin? Martin is a Missouri lawyer who made several unsuccessful runs for office and was eventually appointed chief of staff to Republican Governor Matt Blunt in 2005. His tenure was rocky, to say the least. The trouble started in 2007 with a request by the Springfield News leader for Martin's emails under the state's Sunshine Laws. That's the state equivalent of the Freedom of Information Act. Martin refused to turn them over, and that put him crosswise with the governor's deputy counsel, Scott Eckersley, who said that actually those emails were public records and they had to disclose them by statute. Martin fired Eckersley, which set off a wild chain of lawsuits, and by the time the smoke cleared, the state had paid Eckersley $500,000 plus another $1.3 million to outside lawyers to deal with all the litigation. When the governor's office finally produced Martin's emails to the press, it turned out that he had been using his office to slime State Attorney General Jay Nixon, the Democrat who was planning a challenge against Blunt in the 2008 election, as well as a Republican judge named Patricia Breckenridge. A state investigation later concluded that Martin had illegally deleted emails, and Blunt decided not to run for office again. After that, Martin bounced around various conservative organizations, including the Missouri Club for Growth and the Missouri Roundtable for Life. He also chaired the Missouri Republican Party through 2012, a year in which Democrats swept races for governor, secretary of state, attorney general, treasurer, and U.S. Senate. Following that resounding victory, Martin decamped to the Eagle Forum, the powerful conservative group founded by famed anti-feminist Phyllis Schlafly. Schlafly, who was herself a lawyer with degrees from Washington University and Harvard, made her name campaigning against the Equal Rights Amendment that would have enshrined women's equality in the Constitution. Martin's tenure as president of Schlafly's organization was marked by acrimony, lawsuits, and accusations of impropriety. It's kind of his thing. Matters came to a head in 2015 when Martin engineered an endorsement of then-candidate Donald Trump over Senator Ted Cruz. Apparently, he and Schlafly thought Cruz and his wife Heidi Cruz were big-time feminists. The board tried to remove Martin, and a lawsuit was filed pitting one of Schlafly's children against the other. Schlafly was by then 91 years old, but she followed Martin to a new competing outfit known as the Phyllis Schlafly Eagles, none of which would suggest that Martin has the managerial skills to run one of the largest U.S. attorney's offices in the country, not to mention prosecutorial skills since he never worked as a state or federal prosecutor. In 2018, Martin moved from Missouri to Virginia. Once again, he ran for local office, and once again, the citizens said, hard pass. But Martin was still head of the off-brand Eagles, and he had his law practice. Plus, he remained active in conservative causes, and look, we all can see where this is going. In 2020 and 2021, Martin championed the lie that Trump had won the election. On January 5th, he spoke at a pre-riot rally and led the crowd in chants of Stop the Steal. On January 6th, he participated in the march on the Capitol. At 2:53 p.m., he posted, "I'm at the Capitol right now, and I was at the POTUS speech earlier. Rowdy crowd, but nothing out of hand. Ignore the hashtag fake news." 4 minutes later, he said, "Like Mardi Gras in D.C. today. Love, faith, and joy. Ignore hashtag fake news." At 2:57 p.m. on January 6, rioters were inside both chambers of Congress. The members had all been evacuated. Ashley Babbitt had just been shot. Vice President Pence was in hiding, and the crowd was demanding that the police hand over Pence and then Speaker Nancy Pelosi so they could hang them. So I don't know what kind of Mardi Gras parades Ed Martin is going to, but it really doesn't sound like any laissez-les bon temps roulé I've ever been at. Later, he represented multiple January 6 defendants, including William Crestman, a member of the Proud Boys militia who pled guilty in 2023 and admitted that he had menaced Capitol Police with a pickaxe handle. Martin served on the board of Patriot Freedom Project, which advocated for the January 6 defendants. Here he is on a podcast called The Tea Party Power Hour, explaining that the people who prosecuted the January 6 defendants should go to jail.
And there needs to be accountability. People say, I don't want to ask for revenge. I'm not asking for revenge. America operates on accountability, however. And if you do something wrong to people, you don't get to say, oh, no, don't be mean to me now that you're in charge. No, we'll hold them accountable. And one of the reasons I think that we should fear for this election in the fall is because there's hundreds of Democrats and some Republicans, Liz Cheney, they know they're going to jail. If we get real accountability, they broke laws, not because I don't like them. I'm a conservative. I'm a constitutionalist. I don't care what your opinion is.
And here he is explaining that he thinks the January 6 defendants should get reparations.
To get to the bottom of it and hold these bastards accountable, and we can do it. But by the way, I'm for reparations. I finally come around to reparations. I believe that everyone that has been targeted on January 6th, they should get a pot of money, like the asbestos money that we got for victims of asbestos, like the other things, and they should be able to go access it.
And so it's not a big surprise that Martin's first priority after Trump appointed him to lead the D.C. Attorney's Office was revenge. He began by firing 30 prosecutors who'd worked on the January 6 cases. Other senior officials with years of experience were demoted to handling low-level misdemeanor cases, a blatant effort to humiliate them and force them to quit. And he launched what he called Project 1512. That one requires a little bit of unpacking. See, a bunch of the January 6 defendants were charged with corruptly obstructing an official proceeding under 18 U.S.C. Section 1512C. That law says that whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes an official proceeding, or attempts to do so, shall be fined under this title or imprisoned not more than 20 years, or both. Now, some of the January 6 defendants argued that or should be read as and. So they said it wasn't enough that they obstructed the certification of Biden's 2020 electoral victory by making the senators and representatives flee for their lives. They argued that you had to also alter, destroy, mutilate, or conceal a record or document or other object to be guilty of obstruction of Congress under the title. And every judge who looked at it said, what are you talking about? The law says or, except for one Trump appointee who said or, seems like it means and to me, and the D.C. Circuit said, what are you even talking about? Or means or. But then the Supreme Court said, and, we're reading it as and. And because they're the ones who get to decide, we all have to pretend now that it says and. And thanks, Chief Justice Roberts. Anyway, Martin is now launching his Project 1512 to examine the 1512 charges, which he calls the great failure of the DOJ. Funny enough, Martin's own client, William Crestman, pled guilty to a 1512 charge. Less funny is that Martin appears to have switched sides in the case of another client, Joseph Padilla. Here he is on January 21 informing the court that the government is dropping the charges after Trump pardoned all the January 6 defendants. And here he is on February 5th asking the court to let him withdraw as Padilla's lawyer. That means that he was both the prosecutor and the defense attorney in the same case, a wild breach of ethics in every jurisdiction. Reuters reports that Martin said he'd stopped all involvement in the cases more than a year and a half ago, that he'd handled them pro bono, and said that he was under the impression that I was off the cases. But as every lawyer knows, once you've entered your appearance, you're not off the case until the court says so, or the case is dismissed. Oh, and by the way, when Martin tried to withdraw his appearance after the fact, the court said he couldn't do it because he'd failed to renew his membership with the federal court in D.C. and wasn't a lawyer in good standing. And while Ed Martin says that Crestman and Padilla were just doing Mardi Gras parades at the Capitol on January 6th, he's pretty sure that other people were doing real violence with words.
Now, okay, sure, Ed Martin is a terrible lawyer, but if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team.
On March 4th, 2020, after the Supreme Court heard arguments in a major abortion case, Senator Chuck Schumer made a poorly worded reference to two conservative Supreme Court justices at a rally.
I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind, and you will pay the price.
The comment was injudicious, and Schumer apologized the next day. It certainly didn't hinder the Supreme Court, which went on to overturn Roe v. Wade in 2022. But Martin has been trying to make Schumer's comment into a crime, launching what he called Operation Whirlwind shortly after taking office. "We will stop the storm of threats against officials at all levels," he told his underlings. Then he fired off a series of threatening emails to the senator requesting that he, quote, clarify his comments from 5 years ago. He said, "Time is of the essence. You have now received 3 letters as well as public discussion. Your cooperation is more important than ever to complete this inquiry before any action is taken. I remind you, no one is above the law." Now, maybe Martin is just confused. After all, he was never a prosecutor before, and he fired everyone with seniority who might walk him through Criminal Investigations 101. To be clear, that is not how criminal investigations go. If prosecutors actually think a crime has been committed, they do stuff like interview witnesses, go to a grand jury, file a criminal information. They do not send pissy emails and have public discussion. And not for nothing, but the statute of limitations on incitement or whatever else Martin is pretending he's going to charge Schumer with is 5 years. So that whirlwind has whirled. And Schumer isn't the only official Martin is publicly discussing. Representative Robert Garcia said on CNN,
"And what the American public want is for us to bring actual weapons to this bar fight. This is an actual fight for democracy."
Martin fired off another nastygram saying, "This sounds to some like a threat to Mr. Musk, an appointed representative of President Donald Trump, who you call a dick, and government staff who work for him." It is not a crime to call Elon Musk a dick. Phew. And it's not a threat to Musk to talk about bringing weapons to a metaphorical bar fight, which is why we're talking about a pointless letter from the U.S. attorney and not a grand jury. According to the New York Times, Martin tried to get the IRL prosecutors at Maine Justice to whirl with him, and he got blown off. And it wasn't for the last time. Remember that video that Devin put out about EPA Administrator Lee Zeldin trying to recoup $20 billion of gold bars from Democratic activist Stacey Abrams? It's a banger. But briefly, the right-wing smear shop Project Veritas secretly recorded a staffer at the Biden EPA talking about the rush to disperse clean energy funds after the election out of fear that Trump would try to claw them back, which seems pretty prescient since the first thing Trump did was order a blanket freeze on all federal disbursements and specifically clean energy funds under the Infrastructure and Inflation Reduction Acts, which is, again, totally illegal, as we've said in about 10 videos. Anyway, the staffer made an offhand comment about throwing gold bars off the Titanic, and at another point in the video talked about green banking. That was a reference to greenhouse gas reduction funds to be parked with nonprofits and doled out as loans or grants to finance environmental projects in partnership with private businesses and nonprofits. Congress allocated the money for this very purpose under the 2022 Inflation Reduction Act, which is, again, a law. Project Veritas edited the video to make it seem like the staffer was talking about green bank funds when he made the gold bars comments, and Zeldin seized on that as evidence that there was somehow fraud in the disbursement of the funds.
Shockingly, roughly $20 billion of your tax dollars were parked at an outside financial institution by the Biden EPA. This scheme was the first of its kind in EPA history, and it was purposefully designed to obligate all of the money in a rush job with reduced oversight.
The whole thing was a concocted scandal, but Zeldin didn't care, and neither did Ed Martin. Over the long President's Day weekend, Martin tried to gin up a federal investigation of the gold bars. To be fair, the directive came from Maine Justice, specifically Emil Bovey, Trump's personal lawyer who was then occupying the number 2 spot at the Justice Department. Bovey is now the number 3 guy since Todd Blanche, Trump's other personal lawyer, got confirmed as the Deputy Attorney General. Anyway, Bovey said he wanted a grand jury to investigate the non-existent gold bars, and so Martin tasked Denise Chung, the head of the criminal division in his shop, with making it happen. Chung, a 24-year DOJ veteran, said that there was no probable cause to open a criminal investigation or to seize those funds. After spending the weekend going back and forth with the FBI, Chung said that the best she could do ethically was draft a letter for the FBI to send to Citibank, which was holding the funds. That letter said there may be conduct that constitutes potential violations of 18 U.S.C. Section 371, conspiracy to defraud the United States, and 18 U.S.C. Section 1343, wire fraud, that merits additional investigation, and recommended freezing the money so the grant recipients couldn't get paid out. But Martin demanded that Chung write a second letter under her own name, ordering Citibank not to release the funds pursuant to a criminal investigation being run out of the U.S. Attorney's Office in D.C., which she could not ethically do, so Chung resigned. Martin eventually sent out the letter and followed up by trying to get a seizure warrant. But according to the Washington Post, a federal magistrate judge rejected the warrant application because, as Chung had repeatedly told him, there was no probable cause. It's hard to overstate how weird this all is. First, the U.S. Attorney for D.C. is a really big job. Martin presenting this warrant himself to a federal judge is like having the mayor of Cleveland out writing parking tickets. It's way below his pay grade. Second, what did Martin think was going to happen there? He's never been a criminal prosecutor. The most experienced criminal prosecutor in his office said, hey, there's no there there. Did he think he was just going to dummy something up and get a judge to go for it? But, funny enough, there was one politician he did not want to go after. On Wednesday, February 26th, the Metropolitan Police Department in Washington, D.C. responded to a report of a domestic disturbance. At the scene, they found a woman claiming to be the domestic partner of Florida Congressman Corey Mills. NBC's D.C. affiliate says that there were 3 police reports filed. According to the first report, the woman showed the police bruises on her arms along with her broken phone and allegedly let officers hear Mills instruct her to lie about the origin of her bruises, presumably by putting the call on speaker. Later, Mills made contact with the police and admitted that the situation escalated from verbal to physical, but it was severe enough to create bruising. The woman, who was, by the way, not Mills' wife, later retracted her statement, attributing her bruises to eczema and claiming that she was just agitated because of jet lag. Mills' office put out a statement saying law enforcement was asked to resolve a private matter at Congressman Mills' residence. Congressman Mills vehemently denies any wrongdoing whatsoever and is confident any investigation will clear this matter quickly. But many domestic violence victims retract their statements out of fear or shame, and police departments often have internal protocols requiring officers to take an alleged offender into custody if there's probable cause to believe that an assault took place. The police's failure to do that is under internal investigation, but here's where Martin comes in, because D.C. is not a state, and so the U.S. Attorney's Office in D.C. acts as the local prosecutor. It's called the Superior Court Division, and it's where Martin banished some of the more senior January 6 prosecutors, sticking them on purse snatchings and bar fights in an attempt to get them to quit. Here, the D.C. police requested a warrant to arrest Mills, a Republican, and Martin's office said no. Hey, remember that time in 2018 when Donald Trump yelled at his own Attorney General, Jeff Sessions, on Twitter because 2 very popular Republican congressmen got indicted just ahead of the midterms? That was a reference to Duncan Hunter, a representative from California, who spent more than $200,000 of campaign funds on personal expenses, including family vacations, Uber rides to his girlfriend's houses, and the gaming platform Steam. He blamed that last one on his 12-year-old son. Trump was also mad about Chris Collins, a New York congressman indicted for insider trading. Funny enough, Collins was at a White House picnic on June 22, 2017, when he called up his son and told him to dump shares of a biotech company after a failed clinical trial. Both men pled guilty and both were eventually pardoned. But this time around, the Trump Justice Department is not taking any chances, so Martin will not be charging Mills. On the other hand, he does spend a lot of time tweeting at, quote, thugs. Here he is under the hashtag MarchBadness tweeting, hey, thugs with guns, you hear that? Yup, we coming. Oh my God, I just cringed so hard I think I pulled something. But maybe we're being too hard on Ed Martin. Maybe he's not corrupt, he just doesn't understand the law or punctuation. Here's a tweet from February 24th in which he describes the Justice Department as President Trump's lawyers. In fact, the Justice Department is supposed to be independent of the White House. Those lawyers may carry out the president's priorities, but they do not represent the president, and they certainly aren't responsible for protecting his leadership. And I'm not sure what Martin intends to do as a U.S. attorney to stand against the Associated Press for its refusal to call the Gulf of Mexico the Gulf of America. That would appear to be an issue of basic free speech under the First Amendment, and it's not the only issue. Here's Martin promising to use his office to pursue lawbreakers or even people who have acted unethically to the end of the earth. Martin appears to have been promising to go after anyone who docks the DOJ employees currently racing to unplug the federal bureaucracy, and that's not a crime. Here he is threatening the law firm Covington & Burling for daring to provide pro bono legal advice to former special counsel Jack Smith. Here he is threatening 4 former national security officials from his official government account based on a rando tweet. No, Susan Rice, Victoria Nuland, Anthony Blinken, and Alex Vindman weren't whispering in Ukrainian President Volodymyr Zelensky's ear. That's internet gibberish, which Martin didn't even bother to verify. And here he is announcing that he'll be discriminating against students and graduates from Georgetown Law School because he's heard they teach DEI there. He said, "It has come to my attention reliably that Georgetown Law School continues to teach and promote DEI. This is unacceptable. I have begun an inquiry into this and would welcome your response to the following questions. First, have you eliminated all DEI from your school and its curriculum? Second, if DEI is found in your courses or teaching in any way, will you move swiftly to remove it?" It should not need to be said that the federal government does not get to dictate curriculum to private educational institutions, but apparently it did need to be said, and so the law school's Dean William Traynor said it. He said, "The First Amendment guarantees that the government cannot direct what Georgetown and its faculty teach and how to teach it. The Supreme Court has continually affirmed that among the freedoms central to a university's First Amendment rights are its ability to determine on academic grounds who may teach, what to teach, and how to teach it." And he reminded Martin that the Trump administration just had to walk back its threats to defund or launch civil rights actions against schools for woke curriculum. The dean noted that the government withholding a benefit to retaliate against disfavored speech is a classic First Amendment violation, and it's not close. Given the First Amendment's protection of a university's freedom to determine its own curriculum and how to deliver it, the constitutional violation behind this threat is clear, as is the attack on the university's mission as a Jesuit and Catholic institution. So much of what Martin has done is wildly inappropriate, as the Democrats on the Senate Judiciary noted in a letter to the D.C. Bar Council accusing Martin of violating the D.C. Rules of Professional Conduct and the Justice Department's own guidelines about 6 ways from Sunday. For instance, Rule 3.8 says that a prosecutor shall not make extrajudicial comments which serve to heighten condemnation of the accused, both because it's inappropriate and because it can poison the jury pool. The Justice Manual says that officials will not confirm the existence of or otherwise comment about ongoing investigations and should take care to avoid implying that a referral from the public will lead to an investigation, and to stress that there is a distinction between reviewing a request and opening an investigation. So when the Department of Homeland Security reposts a conspiracy theory by the Doge Bros and tags Ed Martin, it is not appropriate for him to respond, "Duly noted, we are on it." But I guess Martin isn't too pressed about rules, and neither is Trump, who first installed Martin on an interim basis and then nominated him for a full term. Martin responded that it was the honor of his lifetime to accept the nomination and pledged to work as hard as Trump does for America, even though no one outworks him. Well, he could start by reacquainting himself with the rules of prosecutorial ethics, maybe followed by a refresher on criminal procedure.
Thanks, Liz. And to add a cherry on top of the crap sundae that is Ed Martin, The Guardian reports that Ed Martin has a history of making derogatory and racist comments. The Guardian reports, quote, "Martin's rhetoric includes falsely claiming Kamala Harris as self-identified as black and calling her the new Rachel Dolezal, claiming Planned Parenthood targets black communities for abortions, claiming that the Supreme Court Justice Sonia Sotomayor made racist comments to white males about their own identity, and invoking false claims about Dr. Martin Luther King Jr. to affirm support for the Republican Party and the Tea Party movement." Now, Ed Martin and the Trump administration are showing no signs of restraint in ruining the lives of anyone who criticizes them or their regime. So now might be a good time to remove your personal information from the internet. And luckily, today's sponsor, Incogni, can help. And you can use my link in the description of the code LegalEagle for an exclusive 60% off discount. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too, because Incogni fights back. These data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all of this information. It might be why you're getting so many spam calls lately, or how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years. In that time, you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you to Incogni for saving me hundreds of hours and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can always collect it again. Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link that's on screen right now or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. But if you decide to keep it, you'll still get the exclusive 60% off discount, so long as you use my link or the code LegalEagle, all one word. After that, click on this link over here for more Legal Eagle, or I'll see you in court.